Well, aren't we all degenerates anyways? I hope everybody's doing well today. Um I I know I am. I'm having a good day. I'm trying to remember if I forgot something. Hate that feeling. What are you going to do? What are you going to do? You just hope that you're not burning anything down and you go on from there. I hope that you had a wonderful weekend. It's Monday. Hi, Allie. K Crimson, thank you. They're pretty even today. I did a good job of evening out the chassis, if you will. Nigel's here. Okay, so let's get going because we have this case, and honestly, this judge, I'm calling him Judge Sedative, tentatively, at the moment, because I will just say, oh, Julie, you're barely late. I mean, we're 2 minutes in. 2 minutes. 2 minutes. This judge is like a sedative, um, but a little zippity doo dah magic. I waited 20 minutes plus to actually see if anybody would show up to these hearings in Thurston today. Nobody was showing up, and the judge was ready to dismiss. And then, hi. Hope you are well. We missed you last week, I think, was it? Or last weekend? Anyways, thank you. Um, but anyway, so I had already written this off. I literally already wrote this off. And then Christopher comes in and says, let's get going, baby. Oh, thank you, Chris. Do. It's going to take a minute to do that. Good God. So frustrating, Streamlabs, but I so appreciate that. Let me heart it. Oh, there, it's back up. Thank you so much for the super chat. Let us get going. Anyways, needless to say, it was almost a nothing. It was literally almost a nothing. And then, ah, yay! Thank you. Oh, look. Oh, there, perfect. Oh, I should get good at that. Um, it was almost nothing, and then it turned into something. So let's together watch it, shall we? Um, Sean, hello. What now? Oh yeah, now my the words work. Is that what you mean? Or what's it called? Streamlabs. He's always late. It's on his permanent record. I wrote it down. Doesn't care. Doesn't care. I didn't change any audio, so I don't know what that would be. But let's go. Here we go. Hello, legal fiction. Hello, everybody. If you're just getting here, like the video or dislike it, whichever interaction method you would like to do, and buckle up because, like I said, I'm calling this judge Judge Sedative. Are you hearing that? You're not. Hold on, something happened. Here we go. Now I bet you will be. Hold on.
This isn't in the way of scolding or anything. This is, court did start at 9. I could have issued the denial order at 9 because you weren't here. I was waiting until 9:30 just in case there was a transportation problem or something like that. I say that mostly because some of the judges would have just dismissed right at 9, or granted it rather, a default right at 9. I would rather the court take a couple extra minutes on the day and see if somebody shows up than have to go through the trouble of having somebody try to reopen it. The court does prefer that things get heard on the merits. Okay,
Thank you so much, Casey Carey.
what's that?
I can hold on to that now if you want, or I have all the other ones too.
All right. All right, so the way this is, actually, I see we have an attorney showing up, Dana Ryan.
Morning, Your Honor.
Good morning, Mr. Ryan. Are you here on the civil anti-harassment calendar?
No, I'm not. I am on the City of Lacey criminal calendar. I must have the wrong court.
Yeah, then we don't give a shit about you. You two deal with that while I say bye to Christopher. Thanks for being here, Chris. Love you and always nice to see you. I'm glad that work is keeping you busy, though. That is always good. And it does look like Bernie Sanders, doesn't it? All right.
Okay, returning to case 24-000246. I'm going to ask each of you to raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
I do.
All right. I'm going to start with Ms. Rabello because this is your request for an order. You've been sworn in. I have reviewed the petition, but I still need to just hear the general facts surrounding it so that we all know exactly what we're talking about here. Okay?
Absolutely. So, to begin, my family and I, my fiance and my 18-month-old son, we had just moved into our apartments, Bellwether Apartments. And we had been moved in for about less than a week when we had had our first encounter with Miss Attaway. It had started with her coming up to our door, knocking on our door repeatedly, saying that she has a leak in her ceiling and asked if we know any plumbers and why don't we know any plumbers and who gave us permission to move in here without asking our neighbors for permission. She had also asked why we didn't have a house. She had continued to ask, well, what was my son's schedule? Why wasn't that communicated to her when we moved in? So I was like, I had told Miss Attaway, I was like, well, respectfully, if you have anything, in terms of like noise complaints or anything, feel free to go to the apartment. So I was like, I am done speaking with you in regards to this, and I closed my door. And since then, I have been communicating with my apartments actively, giving them every piece of information, every encounter that me and Ms. Attaway have had. Since that first encounter, things have progressively gotten worse. There was an instance where we'd opened our door one morning and there were brooms and mops and like a Swiffer that were blocking our exit of our apartment because it's where we're at. You have to go up 3 flights of stairs and then it's just our apartment up there, and then up to the side of us there's nobody there, and then there's stairs to get down. So she had put the brooms in between the stairs and the wall so that way I would like trip or something going down the stairs with my son.
I'm going to interrupt you here.
Absolutely.
Did you see her do that?
I did not, but I did purchase a Ring camera after that.
Okay. All right. Go ahead and continue.
When I had given that information to my apartments, the apartments actually did contact Miss Attaway, and she did say that it was her who put them there and that she must have forgot that she had left them there. And then after the matter, she had started to take a broom and thump on her ceiling, so my floor, and at all hours of the night. My son is asleep from 8 p.m. to 8 a.m. every day, and he's a really hard sleeper, so he's like knocked out throughout the night. That doesn't faze him at all, but it does faze me. And this one particular instance in regards to the case number that was referred in the matter.
It's working again. Oh my gosh, Mark, thank you so much. Welcome to all the new members. That's 20 new members. We did a members only yesterday. We all went to a wedding together. I will tell you, not a pleasant wedding. There was a lot of screeching involved in members only yesterday. But welcome to all the new members. Thank you again to Mark. That's amazing. Seriously, amazing, amazing, amazing. So amazing. Thank you so much. I'm so glad it's working. We had a little scare there for a little while, but wow. That's so generous. This judge is literally, can we call him Judge Adavan? Like, he is, like, just, even me, my reaction there was subdued because of his effect. Thank you so much.
When I had to call the police. It was about 5 o'clock in the morning. I had heard the thudding so hard that I checked my son's baby monitor, and the baby monitor was shaking off of the wall. And he was like, I could see his cheeks moving in his crib. He was like shaking in his crib because she was thumping so hard underneath his room. So I had started to record, and I was like, I had followed the noise because I was like, what is going on? Is somebody in trouble? Like, what's going on? And then I had followed the thud. The thud was coming from Miss Attaway's apartment. Again, this was at 5 o'clock in the morning. I had knocked on the door because that's what my apartment had advised me to do. Hey, if there's a noise complaint between neighbors, knock on your guys' door first, try to solve it between you guys first, and then come to us. So I was doing that. When I had knocked, she had waited a couple minutes and a couple more thuds, and then she swung open the door and swung the broom at me. If I had not stepped back, the broom would have struck me in the head. Then she slammed her door, said some profanity, and then I walked up to my apartment and I called the police. And the police were on their way. I had continued to record because I just had a feeling. Miss Attaway then exits her apartment again. She tries to walk up the stairs to come up to my apartment. I stop her by the mid stairs, and just by verbal confirmation, I just say, stop. I'm like, you cannot come up here. You do not have any rights up here. You need to stop. The police are on their way. Like, the police are on the way. And you could tell she was intoxicated. Every time there's been an encounter with her, it's been when she has been intoxicated. So far that she's been stumbling over and anyways, so she had like stumbled and sat down, waited a couple minutes, and then said, thanks for knocking on my door. And I said, thanks for banging shit on my roof. Sorry. And then she had started this like crazy laugh. Like, I don't want to imitate it because it's in the recording. But yeah, and then the police arrived. I had discussed with them what was going on, and so sorry. And then they said, okay, we're gonna go try to make contact, and then we're gonna try to arrest her, and then see where it goes from there. Yeah, because they found probable cause for assault in the fourth, which is listed in the police report as well. And they tried to make contact with Miss Attaway. They were knocking, knocking, knocking. She opens up the door completely naked. And then the police ask her, hey, can you go put on some clothes so we can talk? She slams the door in the cop's face, locks her door, doesn't answer the door for them the rest of the time. Police come back up and say, hey, we can't really go in there unless we have a warrant. We're going to refer this to the prosecuting attorney. Things you can do to protect yourself until then is you can go and get an anti-harassment order or a protection order. And then we will refer this to the prosecuting attorney, and then they will contact you from there. And then since that accident, Miss Attaway had put bricks in front of her door. One has a Bible scripture on it saying, God will get me out of the things that I cannot, with a date on it. That's the date that we moved in. And then she was carrying the other day when I was coming home from work, she was carrying the brick. She had walked out of her car, looked at me. She was intoxicated and she had the brick in her pocket and she was just drunkily walking back to her apartment. And then she like does it so slowly and she knows when, like every time that we're outside, she's outside and she just stares at us. So, and that's very concerning because I have my 18-month-old child. If she were to come at me with this brick while I have my 18-month-old child, I could probably take a hit with a brick and survive, but my son cannot.
Objection, Your Honor. Is she an expert witness as to who can take a brick to the face? Also, how do we know how good of a shot the other lady is sending the brick over? I have questions. I have questions. I have questions. Thanks for being here, guys. If you're just getting here, yes, this top is great. It's a top, not a dress. Unusual for me, but it is. And this, again, what is going on in Washington State? Why is it so fucking terrible to live there some places? Let's see. I mean, maybe the lady's gonna dispute all of this, right? Maybe.
So it is very concerning. The harassment hasn't stopped. Our apartments have issued her a comply or evict because of the harassment, and they specifically said because of harassment in the order. And that's why we are here today.
Okay, thank you. Ms. Attaway, I anticipate your version will be somewhat different, but you've already been sworn in. This is your opportunity. What would you like me to know?
My first time meeting with my neighbor, I'm not really good with names, was as we were both walking into our building, crossing, saying, hey, never had officially met, but waved. About a week later after they had immediately moved in. So we're walking past, going different directions. They're both coming in or both going out. And I actually stopped them and said, hey, my name is this and that. Okay, hi. And I met.
This and that. Ma'am, you're in court. I'm not sure this is the time to this and that your name. Is it?
The family invited me up into their home as they were coming in with another relative that I don't know them to be one of the three that lives there. And we went inside their home and we chatted. They asked me, can I show them where this began because of a leak that was over. I live directly under them. I live on the second, they live on the third. I've lived in the apartment since March. So I came in. The family continued to do their normal things. The baby was going places. I think the gentleman and the lady that I don't know to be a resident started doing haircuts. I lifted up the mat as me and the missus were speaking, and we were looking for wetness. So I didn't see any wetness. We talked about going swimming. We have a pool at our complex. We talked about how long have you not been together, but just neighborly things, just getting introduced. This is our very first physical contact. After minor chats, maybe even 10 minutes, I gotta go back. I'm left. I went to my home, did whatever I was going to do that afternoon. I'm not sure if I was drinking. Maybe 10 minutes later, it dawned on me that I didn't leave my phone number. If we were talking about.
Oh. Pro tip. If you don't know if you were drinking, the answer is probably yes. If it's not a solid no, it's a probable yes. Oh my god. Hi Patrick, this is She was seeking wetness at her neighbor's house. She went to her new neighbor's house. They were cutting hair? That came out of nowhere. What is that about? The baby was babying. The others were hair cutting. The wetness was being sought. The two ladies together were seeking wetness. I mean, that can be a very good situation. I'm guessing in this one it is not that good situation where you have two ladies crawling around seeking wetness together. That definitely is a good situation, but not in this case. Not in this case.
Going swimming at the complex. If there's any other leaks that they could call and let me know about, just to have a neighborly number. I got a card that I had gotten from another neighbor, tore it in half, and I was kind of in my mind thinking this is a neighborly chain that we're starting. So I wrote my information on it, took it upstairs, say hi, hey, nice to meet you. Here's my number, call me. The note said, welcome to the building, my name, phone number. They took it. I don't think there was any conversation about anything else because we had just got done talking about minor stuff. They took the number, I went home. Shortly after that, I returned. This is the same day, or this will be my third visit. I said, hey, this is loud. It's been that way for a while. On the third visit, I happened to notice that there was a ball in the missus' hand when they opened it. The gentleman was right behind the missus, grabbing the baby. And I'm thinking, I asked, do you guys normally play sports inside of a third floor apartment? I don't know, have you ever lived in third floor before? So these were just chats to see, is this something that's going to continue? This is, again, the very first day of a physical contact. We had already exchanged numbers, but we didn't exchange. I had already provided mine. So I think on that visit, the third instance of that day, I think the questions that I were asking, she didn't like them. I was saying things, wasn't rude. I was asking kind of informative questions. What time will this happen? Are you used to living in apartments? I'm not. Is this going to be something regular? And I think maybe 5 questions later, she's like, I don't want you to talk to you anymore. Anything else? We're just go to the complex. I have not spoken to her physically since then. I am a smoker. I am out in the parking lot at least 5 times a day smoking my cigarettes. I work evenings. I work at least 5 days out of the week. So between those times, you won't see me. I don't think I've seen this person other than if you see a car and somebody gets out. There's no glaring. The brick. These are things that I'm placing in front of my door that my neighbor has to pass to go up, but they're not for her. They're not intruding. The complex has not sent me any information that says, hey, you're blocked fire hazard. So someone, and just for information, there's 2 bricks. And this was an instruction from a church matter that says, put something spiritual on the brick and put it where everyone can see it, or as many people can see it. I live in an apartment complex, to put it in the back window, it doesn't follow the instruction.
My church comes around and checks out our apartments, making sure we put our bricks in the right location so that our neighbors are sufficiently bricked about us. What in the fuck is she talking about? Also, Mark, that's I hope it's not in healthcare. That's all I'll say. I will hope it's not in healthcare. Her nighttime job. Be much better if she's just a lady of the night. I mean, maybe that would explain the naked part. I sleep naked.
So, and these, I'm not sure of the note, because the note was written by another family member. This is how they put their information on their brick. My brick was written fully on the brick and marker. So I'm not sure of how she read my child's note sitting directly on my doormat. Brooms and sticks. If I'm cleaning, I set them to dry. I don't go upstairs to set them down. They're directly in front of my door, on my doormat. I can't be responsible for making people feel uncomfortable with, I think, okay questions that someone should know in a civil world. I can't be responsible for someone getting uncomfortable with things that are of my right to do. Police coming to I'm not sure why there was a knock at the door or who answered the door when my neighbor came down on a particular day. I recall the police coming. I don't know what led her to that. And I didn't want to speak to the police at 5 a.m. After so much knocking and banging and yelling my name, I did open the door to say, hey, this is not a good time. I'm sleeping, and I sleep in the nude. That's just how it's been. I have worked at the same corporation since 2007. I have worked graveyard for 20 years. I have children of all ages, and I never have been questioned about anything of violence that I would ensue on anyone. I would be bothered if I was to be told noises is making someone uncomfortable. I'm a domestic abuse survivor. That's how I ended up. I'm a Midwesterner and I live in Seattle. Moved to Washington, first to Seattle because of a flea. My steps to move to Olympia in March was to dial back kind of the noise, the traffic, decrease kind of random violence. And I had such a peaceful time until March where I could no longer sleep at my sleeping hours that I have been sleeping for years. I have not carried bricks ever in my life in my pockets, ever. I have not staring at one neighbor or another, and I wouldn't do anything to anyone's children, even in defense. But I believe that physical is only for defending yourself. And that's because you need to physically defend yourself and you don't have time to get help. I am not aware of multiple violation notes from my apartment complex. I received a phone call the day after the 3 visits in a day. And after I received that information in the phone call, I have not, and that was in July. I have not been to anyone's door. Again, I don't carry bricks.
Okay, I'm gonna be the asshole who says it. If you don't carry bricks, how did you get the brick to your house? I'm just saying. You're allowed to carry bricks. You're allowed to carry them. You don't have to lie about that. But lying about it makes it suspicious because it's obvious. You talked about the bricks. You wrote on the brick. How the fuck are you going to write on a brick without carrying it? How'd you place it where it needed to go without carrying it? Doesn't make any sense. Also, Roll On G has reminded me of a funny story. My ex-boyfriend, who is my roommate, was in the house one time sleeping naked on the couch when somebody broke into the house. And let's just say that did not go well for that person that broke into the house. Yeah, scary naked men. This was before I came around anyways, but he stole the guy's wallet and kicked him out of the house. He took his wallet. It's like, what the fuck are you doing in my house? And took his wallet and then kicked him out of the house. Oh, I thought it was so funny.
Um, when I did get the call about the mops and brooms, I said, oh, I must have left them out there drying. Let me move them. I didn't see any mops and brooms at all. I believe things are being made and elevated or created without without reasonable conversation. That's all I believe I have been told about answering to.
Is there anything else you'd like me to consider?
I would like you to consider that if I am videoed in my home, that could possibly be violate unlawful.
Okay. All right. It is your petition. Do you have any final words? You don't have to say anything additional.
I do have my fiance who did want to say something in regards to this, if he wanted to.
You could have him sworn in as a witness, but he's been sitting here listening to the whole thing. So I would anticipate he's just going to say essentially the same things that you said. Okay. All right. Well,
May I
given,
judge?
you may briefly.
It is correct that I am astounded about moving from the residence. And my lease, I'm not within a lease, so I am free to leave as of August 30th. Will be doing that gladly.
Okay. Given what I've heard, I have balanced the facts that I find from both sides. And I am going to issue an anti-harassment order. What I did not hear.
There's a magic 8-ball in the chat. I think we have a magic 8-ball feature in the chat. What is it? Exclamation mark 8-ball and then a question or something like that. I thought it would be a big D as well, but also she sort of admitted to some of the shit.
I think would have been appropriate. Sounds like the main problem, aside from potential, aside from an alleged assault and potential behavior that may have frightened Ms. Rebello, the knocking on the ceiling. And I heard no denial of that, and I have decided, in part based on that, that I am going to issue this order. I am not going to be putting any distance restriction on here. So I'm not making you leave the apartment or anything of that sort. I will indicate, however, that if there is knocking on the ceiling, which is her floor, that is audible from her apartment, that would be a violation.
Okay. I think the command is exclamation mark 8-ball question. And I do think reseller road trip adventures, we got your answer. It says you said 8-ball, will I finally get divorced? And it responded, hire a damn lawyer. So I'm going to take that as a yes. Then K Crimson asked Magic 8, which I don't think is the right one. I think it is exclamation mark 8 ball. So what was the next question? It's a sassy 8 ball. It's a sassy 8 ball, I think. I think. But I think you'll get divorced. I concur with the 8 ball. I've said that before. Ah, dear. Ay. He's taking so long, Paisley. So now uncomfortable.
other. And so I've
I just skipped like 8 minutes.
okay. You'll each have a copy of this in just a moment. Because you live so close to one another, I've had to make some changes to the standard order. The form doesn't really give us a place to do that except for a one line that says other. And so I've had to compress this a bit, and I hope everyone can read it. Just in case you can't, I'm going to make it very clear right now. No attempts to communicate with the petitioner. That would include pounding on your ceiling. You're not to go within 50 feet of her any place outside of the apartment building. When you're going to your apartment, you can go to your apartment. Don't go up to the third floor or approach her apartment. And anything else in there? Standard distance is 1,000 feet, and obviously that's not going to work when you live right there. I believe that covers everything that I ordered. No harassing, no contacting, just hopefully the two of you can live your lives, hopefully quietly and peacefully. But I did find sufficient basis for there to be an order.
Thank you.
Do you have any questions?
I do not.
Okay. Do you have any questions? I'll have copies for you here in just a moment.
Okay, and then he literally proceeded to be slow, so slow, all so slow, constantly slow, the slowest of molasses slow, and we've moved on. He, like, seriously, Judge Sedative, Judge Valium, Judge Ativan, he's a Pam, or an Ann, I guess. I always say, like, all the good drugs with the Pam at the end. Diazepam, lorazepam, alprazolam, you know, the AMs, I guess. I don't know. Anyways, we are going now to Bromlich's Court. I want to talk to you guys about this. This is a case that is weird. Judge fucking lays down the law, and I'm here for it, but I just think it's going to be very interesting. I'm trying to remember if it was the first hearing or the second hearing. So we had 2 interesting hearings today. I'm pretty sure it was in the first hearing, because the second hearing was the rich lady. That's right, rich lady. You heard that correct. So 12:30 and 11. So 11. That's the one. Give me one moment and I'll put it on the screen. Yes. Judge doesn't show up. This guy's boring. His case just became a felony case. It's really quite lame and boring. But then this case is the one I'm talking about.
Case Ms. Hicks.
Nothing further from the front of the court, Your Honor.
Okay, all right, Mr. Rice, you can step out. Thank you. Yeah, we'll take. Any other jails this morning?
No, he was the only one in jail.
Okay, we have two people outside. Do you want, which case do you recommend we call first? We have a Robert Moss.
If Tim Leiter is not here yet, then let's pass Moss. We put this over for a court-appointed attorney, so David Albane can be called next.
Okay. Is Mr. Leiter, is he?
MB, I did see that he had a 55-minute hearing. I didn't actually look and see who it was. Was it the bathtub people again? Were they having an agreement, or are they fighting again? Fuck. That's okay though. Judge Kirkham leaves them up, thank God, for 1 month. So it's less prioritized on my courts to watch list nowadays. They had another fight? Yes! Love it. That's St. Jacob, right? Oh, I'm terrible. Look at me just reveling in their misery. Anyways, let's watch this. That'll be tomorrow then. Yay!
There. Right.
I didn't know he was supposed to be.
He did let me know that he was earlier today when we chatted. He let me know that he was in referee Sweeney's prior to this, and I told him that I had a jail and another in person that we could handle before his.
Okay, and Mr. Moss apparently paid $1,500 this morning. Is that correct?
Yes, that was what we were requesting,
Okay.
to not ask for jail.
Oh, you want to do some of the recalls?
We can do those, or Mr. Albane.
Oh, he doesn't have, Tim? No.
Mr. Albane already has a finding of contempt, so he was coming here for sentencing unless if he failed to provide the 5 written offers from dealerships.
Have you received those?
I have not.
Okay.
I don't
Right,
know if he
we'll
brought upstairs with him.
Okay. Okay. Looks like we have one. We'll have him stop in from the.
This guy shows up in court in person. He's going to be tough to hear, but you're going to hear from the judge and the friend of the court mostly.
I have notes here.
Matter, Sarah Thomas versus David Albin.
You, David Albane? Okay, can I have a seat there? Mr. Albane is appearing personally as directed by this court. He appeared before the court. Also present is appearing via Zoom as Monroe County Front of the Court Attorney Rebecca Hicks. Mr. Albane was brought before the court last week. He was ordered to appear today with 5 dealer estimates of his Harley-Davidson motorcycle, which, if the court recalls, he purchased after selling some real estate. Is that correct? And he did not use any of the proceeds of that real estate to apply against his rearages. The rearages exceed $11,000. Is that all correct, Ms. Hicks?
That's correct, Your Honor. That's how we ended up with this finding of contempt and an order from you back in 2021 for him to list and sell the motorcycle.
And the court ordered him to sell it back in October 2021. Is that correct?
That is correct.
And that as of today, and we're almost October of 2024, 3 years later. Are you Sarah Thomas? No. Okay. What is your name? Okay. All right. Waiting for your attorney. Waiting for your attorney. No, you can sit there. Your attorney. All right. For the record, Mr. Albane has provided 1 Psychocare 50-point inspection.
So if you caught that, the judge has already ordered him in 2021 to sell his Harley-Davidson motorbike that he bought with the proceeds of a house sale instead of paying off his child support arrearage, which is approximately $11,000. Judge is not happy about it. Okay? I know he sounds like he's, MB. It gets even crazier than that. I was surprised I caught this. I was like, holy shit, I've never heard them do this.
With attached to the card from River Rays and Power Sports. Looks like a technician examined it. And there's a figure down at the bottom of, I don't know what that, if that's a, what they're going to pay for it, or it's a value of $13,805, Mr. Albane.
That's the.
Okay, what are they willing to pay you for it?
Pardon?
What are they willing to pay you for it?
They said.
Okay, where are the other four estimates?
I didn't.
Okay,
I
all
was
right.
just, my stomach dropped.
Okay.
It's all gonna be the same, and that's.
You've not complied with any of this court's orders, Mr. Albane. So can someone pick up your motorcycle? Is it out in the parking lot? Can someone pick it up for you?
No, it's.
Okay, all right. All right, you got 30 days hanging over your head. And you know, you decide obviously to buy yourself 30 days. Ms. Hicks, what's your recommendation this morning? Clearly, Mr. Albane is ignoring this court. I don't know if we have the sheriff's department seize the motorcycle. If that's additional cost, that's going to reduce the value if we have a receiver appointed to sell that.
Right. We were trying to avoid that. We were trying to just have him sell it. If you're saying that the documentation he provided you is showing $13,805, that's greater than the total arrearage on the case.
Okay. All right.
So if he
the
would just sell it, he could have this
but obviously,
case closed.
we need to obviously catch Mr. Albane's attention. That order still continues, Mr. Albane, but convince this court the court should not order you to serve 30 days in jail today. Then when you
Does anybody have any reason why he shouldn't be going to jail today? The judge is giving it to him in his hand, says, convince the court. Why? And he drove the motorcycle to work or to the court that day. What a fucking, I mean, sir.
don't sell it, we're going to start over. Going to be a second fine, it's not be up to 90 days. Okay. Convince the court why the court should not order you to serve 30 days in jail.
Your Honor, my son.
I don't want, sir, you're ordered to sell it. Nancy, can you please call for a pickup, please? Mr. Albane, I want to hear this. The garbage you're feeding the court, you're ordered to serve 30 days in Monroe County Jail.
Yes, sir.
And we'll get over there for lunch, and we're going to give him a date shortly, maybe in about 45 days, Ms. Hicks, and we're going to put it on this court's docket, because if he has not sold it, we're going to start second finding of contempt. The court's going to reiterate, Mr. Albane, you are ordered to sell that motorcycle. So we're going to give you a couple weeks when you get out of jail to have sold that. What do you believe is reasonable period of time? Maybe see if he's going to serve 30 days out end of September, maybe mid-October.
Certainly.
Maybe your Mr. Leiter, Mr. Moss is back here.
Wake him up when September ends. He is being taken into custody today to serve 30 days of jail because he wouldn't sell his motorcycle and pay his child support. Now that is stubborn and stupid.
Right there. If you want to, if you talk to them, you can talk to them on the hallway. Okay. Are you available on the 22nd or 23rd of October, Ms. Hicks?
Let me check. Yes, Your Honor, I'm available both days.
Okay. All right, we'll set it for Tuesday, October 22nd, 11:15 in the morning. Mr. Albane, you can appear by Zoom. And if you will start contempt proceedings, the plaintiff attorney to represent you on October 22nd if you've not sold the motorcycle and satisfy these rearages. And at that time, the second fine contempt would be up to 90 days. Yeah, you can avoid additional time if you have the motorcycle sold and you pay off these rearages. We will, did you want a copy of this? Got a copy? All right. Any question, Mr. Albane?
Your Honor, for that order with the jail sentence of 30 days, are you going to give an amount that he could pay in lieu of serving that full 30 days?
What do you recommend? Yes, we'll give him an alternative to post a cash bond.
Give me one sec. I would say $3,000, Your Honor. That's a little less than 25% of his current arrears balance.
All right, of course, that bond amount of $5,000 cash only. So you can serve 30 days, if you post 5,000 cash, you can avoid the 30 days. You still got to sell the motorcycle. But if you want to be home for Labor Day, reach out to family and friends, they can post $5,000 cash to apply toward your arrearages, not to fines and costs, but toward your arrearages. And we will set another date, October 22nd, around 15. Review for the proceedings. They can come outside there. I'm sure they'll come to the window.
We can make you look like this too, Mikey. I promise. This guy has to sell his motorcycle.
I'll staple this invoice from River Power Sports to the file. The record again reflect that Mr. Albane has not complied with orders of this court regarding sale of the motorcycle or securing 5 estimates as to its value. I provided 1. Yeah, continue. Now just have them come outside door.
They're taking him into custody.
You send you'll send an order over to the sheriff's department, correct? Regarding the jail
Yes, Your Honor,
funds?
I'm typing it up right now. And once I have it signed by you, I will be sending it over to them.
All right, very well, thank you. Point, sir. Mr. Albane right here, we'll send an order over to jail. He's been sentenced to 30 days for contempt. So I trust he'll go over there in time for lunch. Thank you. And Ms. Hicks will email a copy of the order over to the jail.
Make sure he gets lunch there.
Get that motorcycle sold. You can go out the side door.
Yeah, go out the side door, no problem. Fucking hilarious, hey? Judge was not playing today. This is a Monday. He was pissed off. You should have sold that over the weekend, buddy. Sold it to a friend and bought it back after or something.
I'm gonna staple inside these notes that I have.
Right? Wouldn't that have been the best thing to do? Doesn't he know a car dealer or two? I know a car dealer or two. If anybody ever needs to sell their car for a court. Now let's zip through to find the lady who owes the money. That's right. A rich lady. Oh, these people. Remember these people? Oh, so much forehead going on here. Let's take a look, shall we? These were the ones they had a TPO against each other. I think they've come to a settlement. Let's watch that.
Type of mediation.
Ron, do you have your client with you?
No, he was logging in.
Oh, okay, well, he's not here yet.
Good morning, Mr. Vitino and Mr. Bruce.
Morning.
Morning, Honor.
So Josh can't send them up, or they have to basically log out and log back in. Is that correct?
ID, so they're gonna get out of his ID, but our ID in.
But when they come here for motion hearings, we send them right down there. They don't have to log out here and get in.
No, because they're logging directly right into us
Yeah.
instead of someone else.
When they log into Josh, why can't Josh send them up here?
Get our ID number.
Right, but why is it different one way versus the other way?
Because when we have motion, they come right into.
I understand, and for mediation to go right into Josh's.
And then he comes in here, and then I break up room. Back to us. I'm the one that's.
Allegedly. That's what. Oh
I
my
see.
God. How exciting.
Okay.
Okay, that's fine. I'm the wizard up here.
Calling the matter of Michael McClellan versus Cameron McClellan.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties having engaged in mediation this morning with Mr. Josh Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Ronald Bruce, representing the plaintiff Michael McClellan. Mr. McClellan appears to be present. In addition, Attorney Matt Vidito is present, representing the defendant Cameron McClellan. Mr. McClellan appears to be present. Good morning, everyone.
Morning.
Morning.
The court has been informed that the parties have reached their own agreement resolution on all standing issues this morning. Is that correct, Mr. Bruce?
Yes, Judge.
Does it also address Mr. Vidito's motion to modify parenting time? That was also discussed and resolved?
Yes.
Wonderful. Who would like to place agreement on the record?
I can.
Please, Mr. Bruce.
Judge, parties have two minor children, Chloe and Caroline. Parties will share joint legal custody and joint physical custody. Parenting time will be the 2-2-3 schedule. Mom will have every Monday and Tuesday. Dad will have every Wednesday and Thursday. Parties to alternate their balance of the week. The child support is to be $532 a month, which is $475 base, $57 ordinary medical. That's to commence after the marital home is sold. Starting on September 1st, my client will pay $400 a month in child support until that time. During parenting time, any guns would remain in a gun safe while the children are present. There should be no alcohol or drug use amongst the parties when they're exercising parenting time, or any supervisor who is watching the kids. In regards to that child support order from the defendant, that would be withdrawn. My client would be withdrawing the ex parte order that was previously entered. There was a PPO filed in Ohio that was actually dismissed, but there is a show cause hearing. I believe the defendant is agreeing to withdraw that. There is a marital home that has already been listed for sale. Proceeds for that will be used to pay the marital bills, namely 2 credit cards, one from Synchrony Bank, the other one from Navy Federal Credit Union. Any other proceeds, if there are any, to be split 50-50 amongst the parties. If the proceeds do not cover those credit cards, my client will be responsible for any remaining balance on those. No spousal support to either party, judge, forever barred. Both parties have relocated to Marion, Ohio. I think they're in agreement that the domicile will be the state of Ohio for purposes of the minor children. There are no retirement accounts. Personal property is to be divided by agreement, with the exception of the defendant wanted a book collection, some Christmas bulbs, and I believe a Christmas tree. Bank accounts, my client would be awarded the Navy Federal Credit Union account and the Huntington account. Defendant would be awarded a Premier Bank checking account. Tax, for purposes of tax exemptions, my client would be ordered the exemptions for Caroline. The defendant would be ordered the exemptions for Chloe. She would like her maiden name restored, that being McBee, MCBEE. And daycare is to be split 50-50. And I think that's everything.
Thank you, Mr. Bruce. Mr. Vito, did Mr. Bruce accurately state your client's agreement?
I think there's a few additions, Your Honor. One with regard to parenting time, they would be using the Monroe County front of the court holiday schedule with two exceptions. One is that Mr. McClellan would receive every 4th of July and Ms. McClellan would receive every Halloween. Other than that, it would be the front of the court holiday schedule as written. Both parties are agreeing to set aside the ex parte order that was entered by this court. They're going to cooperate to remove my client's name from the joint bank account. There is no retirement or life insurance. With regard to the child support, the responsibility for medical expenses, extraordinary medical expenses is 75% paid by plaintiff, 25% paid by defendant. And that $532 a month would commence the first of the month following closing on the sale of the home. They were agreeing that my client would receive the Christmas decorations and her book collection, and any other personal property is going to be divided as agreed. And the clarification is that during parenting time, Mr. McClellan is agreeing to keep the firearms locked in a gun safe, not just in the gun safe, but locked in the gun safe. And I believe that is all the terms and conditions. Oh, wait, no, I apologize. He's going to keep his Jeep Grand Cherokee and the Ram 1500, and she's going to keep her Jeep Renegade, and they're each keeping the debt thereon. And that's it.
Thank you. Mr. Bruce, are those clarifications acceptable?
Yes, what was her car?
Jeep Renegade. I think it's a 2021, I think.
They're agreeable, Judge.
Right, thank you. Right, Mr. McClellan, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
I do.
Thank you. All right, Mr. Bruce, you can begin with Mr. McClellan, please.
Mr. McClellan, do you recall coming to my office having a complaint for divorce filed in this case?
Yes.
And at that time you did live in the state of Michigan, County Monroe for 10 days, correct?
Yes.
And 2 children born of the marriage, Chloe and Caroline, correct?
Yes.
Your wife, to your knowledge, is not currently pregnant, correct?
Not to my knowledge.
And you believe there's been a breakdown of your marriage such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
No, I don't believe it can be preserved.
Okay. And you wouldn't reconcile, get back together with your wife if the judge weren't to grant you a divorce, would you?
No.
I think the 6 months, Judge, is up on September
11th. Yeah, just a couple weeks.
We would ask the court to consider waiving that. Mr. McClellan, do you believe it's in your children's best interest to waive the 6 month statutory waiting period?
Yes.
You believe your kids would benefit from having some finality in this divorce, correct?
Yes.
And you're asking the court to waive that 6 months, right?
Yes.
You heard the terms of the divorce. You don't have any questions in regards to that?
No.
And you're asking the court to adopt that as your final judgment of divorce, right?
Yes.
Nothing further, Judge. Thank you.
Thank you, Mr. Bruce. Mr. Vidal, do you have any questions, first of all, from Mr. McClellan?
Just 2 questions, Your Honor. Mr. McClellan, have you disclosed all of your assets to my client during the pendency of this divorce matter?
Yes.
Have you hidden any assets?
No.
No further questions.
Thank you, Mr. Vidal. Questions for Ms. McClellan, please.
Yes, thank you. Ms. McClellan, you've heard the terms of the agreement that have been placed on the record.
Yes.
You're asking the court to adopt those.
Yes.
You believe that they're in the best interests of Chloe and Caroline?
Yes.
With regard to the mediator was neutral during mediation, right?
Yes.
He didn't take sides?
No.
Okay. Now the parenting time provision, you heard that placed on the record, and all the provisions are stated accurately, right?
Yes.
And you didn't, with regard to that agreement, you weren't forced into that agreement by anyone.
No.
You're doing it of your own free will.
Yes.
Okay, and you've heard the testimony of Mr. McCall on the record. Do you believe that he's being truthful?
Yes.
Okay. Are you currently pregnant?
No.
Are you satisfied with my representation?
Yes.
Okay, I have no further questions. Oh, wait, I'm sorry, one other question. You've heard that Mr. Bruce stated on the record that spousal support is forever barred. You understand that you can't come back at a later date and ask for spousal support, right?
Yes.
Okay, it's forever closed, that issue.
Yep.
All right, no further questions, Your Honor.
Thank you, Mr. Vendo. Mr. Bruce, do you have any questions of Ms. McClellan?
No, Judge.
You'll prepare the judgment, Mr. Bruce, is that correct?
I will.
Of course, the court recognized that the statutory 6-month waiting period is just in a couple weeks, so the court will in fact enter the judgment of divorce upon the presentment. Court would like to thank Mr. Walker for his assistance this morning, as well as, of course, attorneys Bruce and Vito for helping facilitate amicable resolution between the parties. The court would applaud you, Mr. McClellan, for reaching your own agreement. Without question, the best resolution is one in which you both participate. Far better off to have the court make these decisions. Based, however, on the testimony that's been presented this morning, as well as complaint filed this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it's ordered upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting divorce from bonds of matrimony. Good luck to both of you. Keep in mind, need to make it good for each other and your two children. There will be challenges in life, but they can all be addressed through effective communication. So make it good. All right, with that, good luck to both of you. That will conclude this hearing.
That'll conclude this hearing. You can zoom out, get the fuck out of my courtroom, the judge says. And I say, well, Judge, is that because you were excited about this next meeting starting? Were you excited because this is not something we normally see? First of all, one of these things is not like the other. One of these things isn't the same. One of these people has 2 lawyers. And, hint, hint, that usually indicates money. This is it's an agreement, but I think it's going to be interesting. We're going to see something rare that we don't often see.
Calling the matter of Mark Mansick versus Rebecca DeVoot.
For the record, this matter is before the court for continued the pretrial conference. Subsequent parties have engaged in mediation with mediator William Godfrey this afternoon. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff father, Mark Mansick. Mr. Mansick appears to be present with Ms. Zagorski. In addition, the attorneys Kimberly Kuhn and Eric Chappell are present, representing the defendant Rebecca DeVoot, and Mr. DeVoot is present with Ms. Kuhn and Mr. Chappell. Good afternoon, everyone.
Good afternoon, Judge.
Good afternoon, Judge.
Mr. Godfrey has informed the court that the parties have reached an agreement on all standing issues, with the exception of custody and parenting time, and wish to reserve that issue until receipt of Dr. Wooten's custody parenting time evaluation. Is that correct, Ms. Gorski?
Yes.
Is that correct, Ms. Kuhn and Mr. Chappell?
Yes.
Okay.
And with the court's permission, Judge, I'll place that agreement on the record.
Please, Mr. Godfrey.
Thank you, Judge. We have one minor child, Maggie Mansick, date of birth October 9th, 2019. Temporarily, and pending further order of the court and without prejudice, the parties would share joint legal and joint physical custody of their daughter. Dr. Wooten has been trying to get a report to everybody for, I'm pushing probably eight months, and it has not come in yet. And the parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party to seek a change in parenting time custody, and that neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time custody, obviously subject to what weight the court gives it, but Dr. Wooten's report we just don't have, and frankly, Judge, I'm tired of waiting for it, so we're going to go forward with what we've got. Is that sufficient?
So that is a very unusual agreement to put on the record. Mr. Godfroy is the judge's preferred mediator. So he's a lawyer, but he also works as a mediator and an arbitrator at different times to handle disagreements and disputes and try and settle them ahead of court. That's the ideal situation. The judge really wants to be able to just like verify agreements as opposed to have to make decisions. But Mr. Godfroy will be the go-between and the mediator. And look at that, Dixie. Oh, I love how it dances. I love how you guys get to see it. Look at that super chat. Streamlabs, you're taking so long. Why are you taking so long? Thank you so much, though. Look at that. Look at the little pair. I love it. That is so sweet of you. Thank you so much. Bill, you going to bed? Good night, Bill. So the reason he's laying it out is because he's the mediator, the intermediary, apparently the independent guy. And again, this is a different agreement than we normally hear. You'll be able to tell as we continue to listen, but that's why he's yay! Do. Thank you so much, Dixie Lords. Amazing. Awesome. Seriously. Thank you so much. But anyways, yeah, so that's why he's putting it on the record. And that's why he's doing the talking. But further to my point, why this is unusual. Generally speaking, whenever we hear of people coming to court, if there is a previous order that's been put in place, even on a temporary basis, courts tend to restrict evidence to things that have happened subsequent to the last order. They don't like to relitigate things, quote unquote. And so I found it very interesting that they basically gave a really easy way to change a custody order by stating that the report coming from the doctor is enough of a substantial change to warrant that change, and also that at that hearing they're allowed to bring up anything in the past regarding parenting. That's very unusual in my experience of listening to these agreements, but it sounds like it's probably just an ace in the back pocket waiting just in case the report comes back really bad or things turn. That's my opinion. Allegedly. I don't know. I'm not a lawyer.
Everybody that for making a record on this, Ms. Kuhn?
Yeah, it's constitutes proper cause or a change in circumstances. That's fine.
All right. Ms. Zagorski, do you think that we've covered it enough?
I do. Thank you.
All right.
So, Mr. Godfrey, in the interim, the parties will continue to share joint physical custody, correct?
That is correct, Judge.
All right, thank you.
All right. Parenting time by the parties is a 2-2-3 parenting time schedule, broken down as follows. Week 1, father would have Monday, Tuesday. Mother would have Wednesday, Thursday. Father would have Friday, Saturday, and Sunday. Week 2, mother would have Monday, Tuesday. Father, Wednesday, Thursday. Mother, Friday, Saturday, and Sunday. This schedule would continue. The parties would utilize the Monroe County Friend of the Court holiday schedule absent a contrary agreement of the parties. For tax exemption purposes, the parties would share the minor child with mother claiming even years and father in odd. This would ultimately be a part of the child support provision of the judgment of divorce and therefore subject to modification by the court. Health insurance coverage for the child. Mother would continue to maintain health insurance coverage for the benefit of the minor child, so long as the same is available at a reasonable cost. Reasonable cost is defined as 6% of a party's gross income. When mother has the coverage, father need not obtain it. I was using, for purposes of the child support formula, a cost of $462 to cover the cost allocated for the child. Any uninsured medical expense would be split 80% by mother, 20% by father, after father pays the first $454 per year of uninsured medical expense. For purposes of the child support formula, it is $828 for the base support. Health insurance premium adjustment is $97. And then the ordinary medical care amount, I will figure that out, but it's going to be it so that we come up with the $753 total. And what I do, Judge, on this, I run it with two different methods. One with the mother claiming the child, and the following year with father claiming the child. That comes up with two different child support amounts. I add those up, divide by 2, and that's where the 753 comes. And I'll just fluctuate the ordinary medical amount to come up with the 753. One year it's 744 to father, and the other year it's 761 to father. So I just take that average and came up with the 753. Any questions by the parties so far?
No. Yes. The exemptions, that's tax year and not calendar year, correct?
That is, it would be even year, calendar year for the tax year so in 2024, mother would claim even though the tax return is filed in April of 2025.
Okay, so it is not tax year, it's calendar year.
Calendar year. Well, it would be the 2024 taxes are filed in 2025.
Okay, and my other question was regarding vacation time.
Hopefully we will have that resolved, but before next summer, after Dr. Wooten's, I did not get into, unless the parties want to agree, 1 week each month during the summer.
Full week. Each month.
Mom pays child support to dad.
Can we just continue on with what we have in place until we get Dr. Wooten's report?
Yeah, that's fine.
Mom is
That's
paying
fine.
$750.
2 weeks non-consecutive.
Yeah.
Okay. Yep, that's fine.
Whatever notice, and then whatever notice there was, whatever we had. I mean, it sounds like we're operating off of that anyway, probably with the exchange time, with the way that they're
yeah, whatever they have been doing would continue.
Okay, so that their prior order, we're just gonna kind of take and put it into this, correct?
Into the judgment.
Perfect, okay.
All right.
Thank you.
As to extracurricular activities, if the parties agree to an extracurricular activity, that cost would be shared 50-50 by the parties. If they do not agree, then the parent that enrolled the child in that activity would be responsible for its cost. The child is in preschool, and that would continue at Stony Creek Preschool. No decision has been made on school for 2025-2026 school year. So this is through preschool right now, so the child would stay in the young fives in 2024. The parties would be utilizing the AppClose device for communication concerning their child, and this should be used for all communications. The calendar for the child, or the calendar on the AppClose device, should also be utilized so that the parties can be kept abreast of any doctor's appointments or extracurricular activities, school activities things of that nature. Child support, mother would be paying to father the sum of $753 per month commencing September 1st of that 2024. And as in the amount that I indicated, that would a uniform child support order would enter anything else involving the child.
Yeah, with the extracurricular activities, if the parties don't agree, does the parent who doesn't agree, do they have to transport the child?
Not unless it's a school-related activity.
Okay.
If it is not school-related, they do not have to take the child to that activity.
And Mr. Gaffer, I think we also agreed that the parties would enable, under the AppClose system, they would enable the ability to make calls on that program as well.
Yes, calls, video, whatever AppClose will allow. You can do video chat or snap, whatever they can do so that a parent can communicate with the child.
Yeah, thank you.
All right. In other words, we're not restricting any part of the AppClose. I mean, the calendar is going to be there, communication, audio, video, whatever ever they can utilize to keep abreast with the child. Then we go to real estate. There's one parcel that is clearly marital, and that's 172 North Center Street, Beulah, Michigan, 49617. That property is only in mother's wife's name, and the mortgage is only in wife's name. Wife would receive that property as her sole and separate property, and there will be a cash settlement that I will discuss infra judge, but mother will receive that. She will have to pay that cash by December 31st of 2024. If that is not paid by that date, the house would be sold. The proceeds, net proceeds would be split 50-50. Any capital gains issues upon the sale or tax consequences from the sale would also be shared 50-50. I'm hoping.
Anybody want to guess what the amount is that Mama's going to pay by the end of this year to Dad in order to keep this house and not sell it? So she has to find cash, liquid, I guess, to make this payment to him. Anybody want to guess? Want to guess? Want to guess? Want to guess? Let's find out. I'm seeing some close guesses.
Hoping we don't have to get there. Mother is pretty confident that she could come up with the cash, which I guess I'll say now is $310,000. And that cash would be paid by December 31st of 2024. If for any reason that does not occur and the house goes up for sale, it's the net proceeds that are going to be divided 50-50. We're not going to parcel out what might be owed to wife's mother or what might be owed to father's mother, each of which puts some money into this house. And there's differing amounts, but it's just going to be split 50-50, whatever that may be, if it has to be sold. If the parties had any interest, or husband had any interest in the property at 15227 Cone Road, maybe Michigan 48159, that is kept by husband as his. As to this property, wife is, as to the one she was awarded, wife would hold husband harmless from any past, present, or future obligations concerning the property. There is, on this property, there was rentals out for the summer. It's on Crystal Lake. Mother would be picking up all income on taxes that we'll talk about in a moment for this property on her return. If there's any sales tax issue, she's responsible for the sales taxes. As to the tax issue, the parties have had prepared a 2020, 2021, 2022, and 2023 tax return.
Oh, wow. Ali. Is he single? Go mingle. That's definitely not 69% of a mortgage here, though, unfortunately, but that's still a good chunk.
Returns, but they have not been filed. Each party would be filing for those years, married but separate. They can use whatever tax preparer they want to use. So if Leland Proshek, who is the current tax preparer, he should cooperate and give the report, the file, to whatever tax preparer each party wants to use, and each party is responsible for their own taxes for the property that they are being awarded. They pick their own income up, and they pay their own taxes or receive their own refund. Automobiles, wife is awarded her automobile, and husband, if he has any, is awarded his. Wife's currently is a 2020 Subaru. Each party shall be responsible for the taxes or expenses, plates, insurance on the items that they have been awarded, and they would hold the other party harmless from any liability thereon. If I did not say it, I should, that as if there's any escrow balance on the Beulah property, that is awarded to wife. And I think there was some taxes paid as part of a mortgage payment, but that is awarded to wife.
Bill, does she also get, I think we also agreed that she gets all of the tax credits associated with the.
Anything involving that property, she keeps. The liabilities, the credits, the escrow, and has to hold husband harmless for any past, present, or future liabilities concerning that property.
That's what Capital Gary said.
As to bank accounts or brokerage accounts, the parties would each keep their own. Specifically, wife had a TIAA brokerage account that was not retirement. She keeps that in a Vanguard brokerage account. Husband keeps his non-retirement accounts consisting of an American Funds, LPL Financial, and a Dearborn Federal Credit Union. There are some joint accounts. One is a Ameritrade, which as of today's date had $1,904. That is to be split 50-50. Hopefully somebody can create a new account at Ameritrade and just roll that over so that each keeps half.
Yeah, I'm sure the bank's happy to
PNC
have it.
checking and a Premier money market were de minimis monies, but those are joint and would be divided 50-50. Somebody's got to go to the bank and just close those out and divide those sums. If either party had any other bank account that they may have in their name, they would keep that as their sole and separate property. As to retirement accounts, husband does not have any retirement. Wife does have retirement. Some of that was premarital, but for purposes of the settlement, all of wife's retirement accounts that she currently has are going to be treated as marital with a division date of December 31st of 2023. Wife would be entitled, or husband would be entitled to any gain or loss from that division date on that account. Any cost by Ann Pastrana to prepare the quadros would be shared equally by the parties. If there's any cost by the plan administrator to implement the quadros, that cost would be shared equally as well. Specifically, the accounts that are being divided is wife's University of Michigan 403B value. Well, it doesn't matter. The 403B, University of Michigan 403B supplemental retirement account, and a University of Michigan 401A. All of these are at TIAA, Craft being managed there. I assume there's going to have to be 3 quadros, but I'm not positive of that. But whatever is there as of December 30th.
She is actually a vice president of the university, one of their divisions. So she is not a professor. She is an executive she's an executive. I think she's a government liaison. So they get paid a lot at universities, especially top tier universities like University of Michigan. I imagine they have quite a robust executive team, and she is one of them. I don't know how long the marriage is. She seems, I mean, that's a high position to have a fucking 5-year-old, but, you know, we don't know all the deets. We don't know all the deets.
First of 2023, it's all marital, and it's going to be divided 50-50 as of that date. Personal property, the parties intend to try to resolve their personal properties on their own division. If there is any dispute, I would ask that the parties request an arbitration by September 15th of 2024. If they request an arbitration, absent a contrary agreement of the parties, I would act as the binding arbitrator. The sole role of the court would be to enforce the award of the arbitrator. Unless the parties demanded the arbitration would be without attorneys, and they would share that cost equally. I have already exchanged some personal property list. Hopefully the parties can go through that and identify really what is in dispute, and they won't need me. But again, I will give them to September 15th. Do the parties think they can accomplish the exchange by September 15th, or do they want to go a little longer?
I mean, he's not losing the money train. He's getting $310,000 by the end of the year. So he should be able to buy a property in Michigan, right? Probably not the same caliber, but he's not out of the market completely. And he's getting child support upwards of $750 a month. Plus, he's got half her retirement. And I think she's probably worked pretty hard for that retirement. So I don't know. I think, oh no, he got awarded a property. So he doesn't even need to buy a house. He's got a property. Look at that. Look at that. So damn, son. Christmas be good this year.
We're fine with September 15th.
We'd prefer September 30.
I don't have a problem with doing September 30. That's just to figure out what they want to keep or exchange.
Is that agreeable, Ms. Kuhn, Mr. Chappell?
Yeah, that's fine. That's fine, Judge.
September 30th, okay.
Yes.
Life insurance, each party would keep whatever life insurance that they may have, free and clear of any claim, title, or interest of the other party. Husband has a number of business interests, all of which are awarded to him. I identified those as Mansig Trucking LLC, Mansig Farm, and AIS Enterprises LLC. Husband is awarded those, free and clear of any claim, title, or interest of wife. Husband shall be responsible for any past, present, or future obligations or liabilities concerning those businesses. On husband's tax returns, which he is filing married but separate, he would be picking up any gains, losses, or profit or expenses in relation to those businesses on his return. Wife picks up everything dealing with the Beulah property as well as her income on her return. And the parties would use that even odd for claiming of the daughter during that period of time too. Even years mother, odd years father. The only caveat with the picking up of the expenses in relation to properties is if the house has to be sold up north of in Beulah, husband and would be picking up any capital gains, if any, as part of that sale. Marital debts, husband shows up on as on 4 debts that wife is going to be responsible for payment of. And the 4 debts that shows up on husband's credit report are as follows: a Capital One account ending in 3703, a Capital One account ending in 7626, and a PNC credit card, I believe it's a Visa, ending in 0703. Those 3 cards are still have an outstanding balance. That outstanding balance is approximately $23,444. Wife shall be responsible for payment of that. She can close the accounts, stop those. Husband cannot charge on those. He was an authorized user. There is one other account with PHD, that's Tom Henry Dog, CBNA, that is a Home Depot City Bank account, I believe, ending in 4105. That has a 0 balance, and that one can be closed out. They were not closed out before, Judge, because there was an order indicating that they shouldn't be closing out or affecting that. So we didn't have that taken care of based upon prior order of the court. But wife can get husband's name off of those 4 accounts, close them out, and eliminate husband's responsibility for any part of those debts. As to all other credit cards that are non-joint, each keep their own, and they shall hold the other party harmless from any liability. Wife would hold husband harmless from any liability on those 4 accounts that I just mentioned, the 2 Capital Ones, the Citibank, and the PNC card. Any other debts that I have missed?
The only thing that I can see is that there was a representation made that there are no loans against the retirement accounts, correct?
That is a correct statement. There had been a loan, but that had been paid off prior to the divorce being filed.
Yep. The last loan is being paid off in 4 days, Bill.
All right.
Yeah.
Okay.
Yeah.
On the retirements?
Yes.
Okay. The health insurance for the parties, each party is responsible for their own health insurance coverage post-divorce at their own expense. If either party had incurred any medical procedure that was not covered by insurance, each party shall be solely responsible for payment of their own uninsured medical expense. Wife would keep her devout last name. She never took husband's surname. Attorney fees, each party is responsible for payment of their own attorney fees and costs. Spousal support is forever barred. And the cash payment due husband by wife is at $310,000, and that would be by December 31st of 2024, and the court would retain jurisdiction over all provisions dealing with the terms of the judgment. Husband would release the cell phone number and phone through AT&T forthwith, so wife would keep her cell number and phone. That needs to be accomplished forthwith. On the property items, the one thing the parties have agreed to, if I can find that sheet, is as follows. Kayaks that are up north would be awarded to wife. The kayaks that are here in Monroe County are awarded to husband. The parties would copy all of the photographs involving Maggie, the minor child, and they would share that cost. That would be done through Walgreens in the Dundee, Michigan location. As part of the judgment, the parties would enter into a mutual restraining order that neither party shall stalk, harass, molest, wound, or any similar type language that would go into the judgment. And I think I've already talked about the app close used by the parties for all purposes. I think that's the agreement, Judge, but I got a ton of notes here. I think I've got it.
Mr. Godfrey, once again, with respect to the Cone Road property in Maybe, that's awarded to the plaintiff husband, is that correct?
That is correct, Judge. Yeah, I mean, wife thinks he's got
Plaintiff husband. So he filed. Oh, but they split the kayaks. Around here, a lot of people have kayaks. It's a very, 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 very popular.
interest in it. He says he doesn't. I'm just saying if he had any interest in it, I think it is only via a trust that will kick in if his mother passes away. So, for purposes of the divorce, I'm just saying to eliminate any concern about that, that's awarded. Whatever interest the parties may have had in that, he keeps. It might be zero.
Thank you. Thank you, Mr. Godfrey. Farrell, Ms. Zagorski, did Mr. Godfrey accurately state your client's agreement?
Yes. Thank you, Judge.
Thank you. Ms. Kuhn or Mr. Chappell, did Mr. Godfrey accurately state your client's agreement?
Yeah, he did, Your Honor, but we did want to specify that with respect to the cell phone, and I know this seems like a small issue, but we've had some controversy with it, that what's required is that Mr. Mansick will either call to let them know that the transfer can occur and that it's her account, or provide a PIN to Ms. DeVoe so that she can effectuate the transfer. And we would ask, I know we said forthright, but we would ask that we could all agree, please, that that be done in no less than 48 hours.
No controversy, Judge. In fact, we Googled how to do it today. He needs to get a PIN and he can do that in the next 48 hours.
Yes, she was.
Wonderful, thank you.
Okay, that was it, Your Honor.
All right, thank you. Mr. Mansick, Ms. DeVoe, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You both need to speak up so we can capture responses.
Yes.
Yes.
Thank you, thank you. Right, to Ms. Zagorski, if you're going to begin with Mr. Mansick, please.
Yes, thank you. Would you please state, you can put your hand down. Would you please state your name for the record?
Mark Mansick.
And is it your testimony today that your marriage continues to be broken down and there's no likelihood that the marriage can be preserved?
I do.
And is it your testimony today that to the best of your knowledge, your wife is not pregnant?
Not that I know of.
Okay. And you heard the agreement that was stated by Mr. Godfrey?
I did.
You understand it?
I do.
You and I have been talking about this for, gosh, about 7 hours now, right?
Correct.
You understand all the terms and conditions?
I do.
And I know that you're not completely satisfied. Is that a fair statement?
True.
But you understand the math
I do.
and you're asking the court to adopt it.
Correct.
And you and I have talked a lot today about if we ask the judge to have a trial, that you could do better or worse, right?
Correct.
And you know those risks associated with going to trial and with agreeing to this today, correct?
Correct.
And with all of that having been discussed, you're asking the court to adopt this agreement?
That's correct.
Do you understand your obligations under this agreement?
I do.
You and I have talked about the tax consequences of this agreement, and is it fair to say that I have not given you any tax advice?
You have not.
And we've talked about the fact that I'm a lawyer, not an accountant, and that you needed to talk to your accountant, correct?
That's correct.
Okay. And you believe that, no, strike that. You understand that spousal support is forever barred.
Correct.
And you and I talked about the likelihood of you getting spousal support if we ask the judge to order it, right?
That's correct.
And that was contemplated when we came up with the final number that your soon-to-be ex-wife would pay you for your interest in the marital estate, right?
That's correct.
Do you have any questions?
I do not.
Have you disclosed all of your assets?
Yes.
Okay, thank you. That's all I have, Judge.
Thank you, Ms. Zagorski. Ms. Kuhn or Mr. Chappell, do either of you have any questions for Mr. Mansick?
Just a few, Your Honor. Thank you. Mr. Mansick, relative to the spousal support being barred, I want to make sure you understand that this is a final order and that what that means is that the court, your understanding is that the court is not retaining jurisdiction over that issue. So this is done essentially forever. You cannot come back at any time for any reasons and ask for spousal support in the future. Is that your understanding?
It is.
Okay. Can you also confirm that with respect to the temporary nature of the joint legal and joint physical components of custody, that you also stipulate and agree that what we placed on the record is a temporary order. Is that correct?
Is that correct?
Okay.
Well,
I'm
I think
asking,
I think he doesn't know because that calls for a legal conclusion.
Okay.
You stated
Well,
it a different way.
yeah, let me rephrase it. You understand, we're all waiting for Dr. Wooten's report, correct?
I do understand that.
Okay, so if after Dr. Wooten's report comes out, we've agreed, and you agree with this, that essentially would be a change of circumstance, or I'll avoid the legal jargon. Based upon what Dr. Wooten report provides, you agree that each of you have the ability to come to the court and request changes.
I understand.
Okay, or an evidentiary hearing on that.
That's where the judge would take testimony and we call Dr. Wooten to testify about why he thinks whatever he thinks.
Right.
Okay, all right, thank you. That's all I had. You did.
Ms. Kuhn, do you have any questions of Mr. Mansick?
No.
All right, questions for Mr. Voot, please.
All right, can you state your full name for the record, please?
Rebecca DeVoe.
Okay, I think we've taken the proofs already on this case, Your Honor, but I'll just reiterate some of the questions. You concurred that there's been a breakdown relative to the marriage relationship. It's irreconcilable and you're asking for a divorce and continue in that regard.
Yes.
Okay, can you confirm that you're not pregnant? It's a necessary question for us. Okay.
Yes.
You like,
No.
you are
You
not
just speak
pregnant.
up. Mr. Voot, you need to speak up. We're not capturing your responses. Are you currently pregnant?
No.
Thank you.
Yeah, when you answer,
Voice
speak
up.
towards that so they
Sorry.
can hear that.
Sorry.
You likewise have participated in this mediation session for a long time today, correct?
Yes.
Do you understand all the terms of the agreement that have been placed on the record?
Yes.
Do you also understand that you do have the right to go to trial and call witnesses, put evidence on, etc.? And the court could make a determination as to what should happen with the things that we've agreed to resolve today.
Yes.
But you're agreeing to, you're waiving those rights in light of this agreement.
Correct.
Okay. And have you fully disclosed all your assets?
Yes.
Are you likewise, is it likewise your understanding that with respect to spousal support being barred, that with spousal support, that is forever resolved? You cannot come back to court and ask for any modification of that in the future. The court is not going to retain jurisdiction of that for any future involvement.
Yes.
Okay. Do you have any questions that have not been answered as of this time?
No, I didn't.
Okay. Thank you.
Thank you, Mr. Chappell. Mr. Gorski, do you have any questions of Mr. Voot?
Just one. Was there a loan against your retirement as of December 31st, 2023?
No, I just did it for 2 months.
Okay, thank you. And then I did have a question, I guess, for counsel and Mr. Godfrey. We're agreeing that Maggie's play therapy is going to continue at this time, correct?
I did not say that, but that was my understanding.
Ms. Kuhn?
Yes.
Yes,
That's correct.
yes.
Yep.
Okay.
That she'll continue with the current therapist. Is that what you're asking for?
It
Play
shall continue
therapist.
play therapy as previously ordered, yes.
Yeah.
Okay, then that's all I had, Judge.
Thank
And
you,
we
Mr.
did not get a
Gorski.
letter from her as well, Judge. And one of the things that I was concerned about, apparently the play therapist said she would forward a letter to you. And I'm assuming if she did forward the letter to you, Your Honor, you would forward it on to the attorneys. I'm not sure why she won't send it directly to the attorneys, but at least at this point, there isn't a letter out there.
That's correct. When my client talked to her about her recommendations and communicating those, she indicated that she would only communicate directly with the court. I explained that the court would then share it with counsel, but to the best of our knowledge, there's been no communication so far.
Very well. And yes, the court has not received anything. Perhaps the front of the court has, but the court is not aware of any communication from the therapist. But if the court is aware of one, the court will certainly forward it to counsel.
Thank you.
And who will prepare the judgment? Will you do prepare that judgment, Mr. Gorski?
I will.
Very well. The court would like to thank Mr. Godfrey for his fine efforts and assistance this afternoon, as well as, of course, attorneys Zagorski, Kuhn, and Chappell. The court applauds you, Mr. Mancic and Ms. DeVoot, for reaching your own agreement. Without question, the best resolution is one which you both participate, as you have today. Hopefully you can continue that progress with respect to all issues involving your daughter, Maggie. You want your daughter to thrive, and she will if you're on the same page. As she gets older, she's going to sense when there's animosity and tension. So you need to always, in her eyes, respect the other parent. It's the little things that are important. Like dad always makes sure you get her a card from mom for Mother's Day, and mom get her a card, or your daughter a card for dad for Father's Day. Those little things mean a lot to children. In that regard, the court did receive a certification that Mr. Boot completed the problem-solving workshop or the high conflict solutions workshop. The court received nothing from Mr. Mancic. Ms. Gorski, has he completed that program and written a statement?
He has completed the program. Did you write a statement?
I did. I'll forward it to you.
He'll forward it to me. I'll send it to the front of the court, Judge.
Thank you. Or you can forward to the court. The court's got the one from Mr. Wood. I'll make sure the front of the court has all of these.
Okay.
But hopefully the parties benefit from that program. That's all the court asks, is that two of you communicate effectively for Maggie's best interest. She's 4. It'll go quick, but you got a number of years you need to work together for her best interest. And I'm sure you both want her to succeed in life and have a healthy relationship with the other parent is critical. Based upon the testimony that's been presented today, as well as previously in the complaint filed this case, again, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Clearly upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Thank you again, Mr. Godfrey. Good luck to Mr. Mancic and Mr. Voot. And now conclude the proceedings for today, and hopefully when you receive Dr. Woon's report, you can come to your own terms and agreement with respect to your future raising of your daughter. So with that, everyone can zoom out and have a good rest of the afternoon.
Thank you.
Your
Thank
Honor.
you, Judge.
Thank you, Judge.
Thank you.
Damn, what in the fuck is taking Dr. Wooten so goddamn long to write that report? 8 months they've been waiting for that report. Isn't that crazy? Anyways, I wanted to show you guys that case because oftentimes we hear people complaining about it's only men that get child support. It's never the woman. And the truth of the matter is, in that case, it was mom paying dad the money for child support because she makes more than he does. Anyways, I hope that you guys have a wonderful, wonderful night. I already did. I've had a great night already. I'm going to go make a pizza, just a frozen pizza, and eat that for dinner. And probably watch some more court and some other shit. Yeah, they were interesting cases today. Selling the Harley out of pocket. That's crazy. We've never seen that before. He took him to jail too, 30 days. Another reason you should go to get a lawyer, right? Anyways, I hope that you guys have a wonderful night. Remember, I love you. I'm proud of you, and I will see you in the next video. Bye. I said bye.
Ways down and